You have 10 minutes. Justice Sossman is participating by way of the internet in the case. I think you know that.
Yes, I was told earlier, and I also noted to the clerk that there is a request for recusal of Judge Sossman and a problem with the quorum, or the ability to have a quorum.
Okay, wait just a second. I don't think that she put the time. All right. Okay. Now you're 10 minutes. Go ahead.
All right. Thank you, Your Honor. What I had just said before is still on the record. Is that right?
It's on the record, isn't it? It's on the record.
Okay, very good. So I have a request for recusal of Judge Sossman, and I don't want to spend the 10 minutes to discuss it. So I'm going to ask that we can either have another date for another quorum, because I think that there's a problem with the quorum.
We're going to proceed today, and you can use your 10 minutes any way you want.
Thank you. Your Honor, I believe that 10 minutes is going to be slightly too little. I've practiced this without any questions, and I've come to about 13 minutes. So I'm not going to try to go over, but I am going to try to present everything that I have. Okay. I have filed what I call an oral argument brief, or what's called an oral argument, and a supplemental appendix to that, which includes an updated docket from the East Boston District Court, which I think is relevant.
Okay, all of us will have that, so to the extent you run out of time, we have that.
Yes, yes. Thank you, Your Honor.
Yeah.
I believe that the brief that I have asked you to read, originally filed, the blue brief, has several questions in it. The first two I'd like to address. The second question first, which is your jurisdiction. In regards to your jurisdiction, this court has repeatedly said that you are here for extraordinary purposes under 211.3, and that it is sparingly used. I believe this case is of that nature. This court has also stated that where necessary to protect the substantive rights in the absence of any alternative effective remedy. And you cite cases in the matter of appeal bonds, as this is. But this is different from those cases because the deprivation of due process has been, since the district court, into the superior court that heard the appeal bond under General Laws 239, Section 5, which is really the dispositive argument to bring to the appeals court or a review. And this court should grant me relief under 211.3 because there has been a deprivation of due process and access to the district court for the appellate purposes. The bond originally was set at $4,500, and I have been allowed to proceed in forma pauperis, although the district court questioned that at the time that the appeal bond was requested. And in fact, after a complaint had been lodged against the judge, also a complaint with his supervisor, which was the supervisor of the court that he presides at, as well as the Judicial Conduct Committee. He was aware of that because the Judge Johnson, sent him a letter to that effect. And he received that letter before trial. I've attached that to the supplemental appendix for oral argument so that you would be able to peruse that. And subsequent to that, setting of appeal bond of $4,500, alternately, the statute also states that alternatively there's a $100 appeal bond to be tendered to the district court. The $4,500 is set for the damages ascertained at the district court level and the possession in the interim before the appeal and during the appeal that is heard. The $100 is after you've given up possession. I was not able to enter the district court to secure the appeal bond of even $100, and let alone the record reflects that the superior court judge should have ascertained either one, the waiver of the appeal bond of $4,500 and or the waiver of the appeal bond of $100, because the questions that was presented to the superior court judge, and forgive me, I did not supply this court with a transcript of the superior court, which I should have, and that is a mistake, because you would find in there those questions were posed to her. What did happen was it was sent to the appeals court, and the appeals court then rendered a decision, which is at Record Appendix 3. Excuse me, Record Appendix 4, the order, based that there was not a subsequent appellate review. This court has stated the same thing. You wait to the dismissal of the complaint, you lose possession, you then file an appeal. I couldn't get in to file an appeal, which is maybe not in the record per se, but it is there. The district court judge has speckled the trial with that he was going to assess damages for sanctions at the end of trial. He was going to assess a sanction at the end of trial to be heard separately. He never has. The district court docket, which is updated and attached on the supplemental appendix for oral argument, states that the appeal came back from the appeals court. The appeal is dismissed. They issued the execution. The execution went. I couldn't get into the building to ask for a stay of execution. I did go to the single justice of the SJC. That was denied. Most likely it was denied because he assumed I had other procedures that I could follow, like going into the district court. The district court, if you look at to substantiate the reasoning that they applied this sanction to deny me access, is listed right at the ruling on the motion by defendant to waive appeal bond. This starts the idea that I have presented to you. And in fact, Judge Mahoney writes at the last paragraph on Record Appendix page 3, I am therefore revoking her motion to proceed as an indigent defendant. Ms. Erickson has abused far too long the privilege graciously extended to her by the court and its personnel. The privilege. It may be a privilege. As I stand here, it is a privilege, but it is a right. I have a right to be here. I have a right to have my case heard. I have a right to present the defenses that I had. Was in the mind of Judge Mahoney was that it was a gracious privilege for him to entertain me at his bench. He writes it in here. This is what is speckled throughout the trial. He also writes in that decision that he says Erickson's defenses in this case are meritless, filled with fabrications that have been heard in federal and state courts and dismissed. In fact, the only thing that Judge Mahoney had in front of him was an opposition filed by the Cambridge Housing Authority that cites Judge Woodlock from the federal district court, and that is apparent at the supplemental appendix at 37 through 45. Excuse me, 46. No, 45. And at page 44 is where Judge Woodlock specifically states that I'm not being evicted as yet. He discusses that there's no TRO necessary, but he basically says, quote unquote, that Erickson would be able to raise her arguments about the validity of her voucher in those proceedings. The voucher, the Section 8, the discrimination, what Judge Mahoney declared was absolutely frivolous because he read the document from the federal court that said it had been dismissed. Evidently, it had not been dismissed on the merits. And this is why I ask this court to take judicial notice of a Commonwealth case that is being proceeded with in Middlesex that I refer to in my brief, Commonwealth versus Cambridge Housing Authority, where they had found a probable cause by a human rights group issuing probable cause signed by the MCAD that in fact there was a discrimination at the time of the tenancy with the Summers. This raises the likelihood that I have a prayer of a chance that there has been a discriminatory act. And in fact, if I may go back, I had tried to file in the East Boston District Court a 60B motion for relief from his judgment. He entertained the motion at the counter. He came to the counter and demanded I leave the court. I filed it on April 12th. It's endorsed on the motion because the clerk had handed it back to me as photocopied with the date stamp on it, that it was going to be scheduled for the 21st of April to be heard. Judge Mahoney, I found out on the 21st, after not being allowed into the courthouse, which resulted in another complaint to the Judicial Conduct Committee of deprivation of access to the court, he endorsed it, denied, with prejudice. This is reflected in the court's, in supplemental argument, supplemental appendix for oral argument, and it also says with prejudice. The district court just says it's dismissed. I couldn't file even a notice of appeal into that court. That is why I'm here asking for your extraordinary relief. The deprivation.
Your time is up, but you may complete your thought.
Thank you. The deprivation of access to the court has a speckling in this argument to you, as well as in the record on appeal, record in front of you, that there has been a deprivation of access, a prejudicial announcement, and that, in fact, when the Superior Court judge reviewed it, she relied upon Judge Mahoney's argument. And in fact, the court rule 239, Section 5, says it specifically she's supposed to take it anew on the bond waiver issue.
Thank you.
Thank you very much, Your Honor.
Ms. Summers, you have 10 minutes.
I'm Norma Summers, pro se for my husband David Summers and myself. For me, it's simply a case of the fact that on February 29th, Heidi Erickson signed a lease for rental of a cottage that we have in Winthrop. And we were out of town at the time. My son, Craig Summers, was acting as our agent. Craig testified under oath that at no time did Heidi Erickson ever mention Section 8 HUD, anything of the fact. In fact, she asked whether she might be able to purchase the property at some future date. On March 10th, she signed the lease, and on March 10th, upon returning from a trip, my husband and I signed and executed the lease and returned it by mail to Miss Erickson. On Friday, March 12th, suddenly the doorbell rang, and Heidi Erickson was at our door at home. She introduced herself as our new tenant. She said that she wanted to get to know us. We invited her in. She sat down, and we had a very pleasant conversation. She said she knew a lot of the same people that I knew at Harvard, that she had gone to Harvard. And basically she had, after about 10 minutes of pleasant conversation, she said she had done a project for Cambridge, and that she wanted, that they were willing to give her a voucher for paying her off for doing this volunteer project for them, and that in fact it was a HUD form that she wanted us to sign. She also gave us a letter explaining the whole thing about HUD, and so I couldn't really see anything wrong with signing. I didn't understand what it was, but I said, well, I didn't seem. My husband said, no, don't sign that. We need to know more about it. Neither of us had any experience with Section 8. So we said, well, I in fact did sign it, to be truthful. I did. And he said, no, he was not going to sign it. And we were going to call on Monday to Cambridge because it didn't sound right. But at any rate, I asked, while we were talking, I asked her why. She said she had spent $1,600 fixing up the apartment, and she said that she had put 3 coats of paint on the walls. And I said, why 3 coats of paint? And she said, well, because she has some cats. And I said, well, aren't they neutered? And she said, well, she used a professional term that I had never heard before, and a light went off in my head, and I thought, oh my God. I got very agitated. She insisted that we sign the form, and as I said, I did, and then she asked if she could have the form, and I said, no, we wanted to talk to Cambridge Court not Cambridge Court, Cambridge Housing on Monday to find out more about it. And she tried pulling the paper out of my hand. And at any rate, bottom line is I see that she has now changed the last page of the lease. She typed in that we gave permission for HUD, that we would agree to it. And it's been on and on and on in court, time after time after time, motion after motion. And we're going along with this. I tried in vain to get 4 or 5 attorneys to represent us, but every one of them was familiar with Ms. Erickson, and they refused to get involved. So here I am pleading once and for all to end this travesty, which I think is just way out of line now. Thank you very much.
Okay, thank you. We'll recess.
All right.